Good afternoon. Thank you for coming and welcome. I'm Ray Banwari, President of the Mounted Police Professional Association of Canada and Vice President of the British Columbia Mounted Police Professional Association, one of the co-litigants in the Supreme Court challenge we'll discuss about today. MPPAC was established in 2010 to fight for the right to engage in collective bargaining through an independent association on behalf of RCMP members across Canada. Today we are in Ottawa as the Supreme Court hears our case to decide if RCMP regulations contravene the Charter of Rights and Freedoms by imposing a labor relations program and obstruction of our freedom of association. As members of MPPAC, we strive for excellence in our conduct and obligations. Today we appear before you and appeal to RCMP management and the Canadian government for fair and equal treatment when it comes to our charter rights. Before I tell you more about our cause, please let me introduce our speakers and guests. First, Rob Creaser, retired Mountie, an official spokesperson for MPPAC, who has been holding the torch for many decades. Beside myself, Gaétan Delisle from the Association de la Police Montée de Québec, and Michael Gendron from the Canadian Police Association, who's here on the floor. We will take questions and be available for interviews and photographs at the end of the conference. And Michael will distribute a statement from CPA President Tom Stamacus, who is in Vancouver today. MPPAC is hosting today's press conference because all members of the BC Mounted Police Professional Association are members of our national association, and MPA was involved in our founding. As I mentioned today, the Supreme Court heard our case and is hearing our case this afternoon, a case of independent employee organizations seeking recognition from the force to represent RCMP members. It has taken over 2 decades to reach this point, and we want to recognize our colleagues who supported this fight at the outset, particularly those men and women who were brave enough to tell their stories and share their personal experiences inside the force. Their words and personal sacrifices gave us the evidence to bring this case forward. These members spoke up before the Brown Commission provided its report on the stresses and abuses inside the RCMP workplace. They spoke up before the media began to look beneath the prized reputation of the force to examine the pension scandal, before the Aurora inquiry, which pulled RCMP leadership into the spotlight. Those members risked not only their reputations within the force, but also their careers. And we and all members of the RCMP owe them our gratitude. We're looking at finally having our challenge decided by Canada's top court. We're grateful that the Supreme Court has agreed to hear our case because it is so important to the men and women of the RCMP. We have long been denied the freedom of association because RCMP management says its staff relations representatives serves our needs. We're optimistic that the court will accept that each member of the RCMP deserves to have their charter rights respected and upheld, and that one day very soon we, like all Canadians, will be allowed to form our own independent labor association. This association will be completely independent from upper management and will engage in collective bargaining with our employer. As RCMP members, we're not seeking special treatment. We're seeking equal treatment. We want the same freedoms that are enjoyed by every one of our colleagues who serve in Canada. We're asking the court to tell the government to do the honorable thing and respect our charter rights. While we're happy to have had the opportunity to address the court, we're disappointed that the government continues to fight against the rights of hardworking men and women of the RCMP. As well, we're certain that the RCMP will not uphold these rights unless it is forced to do so. We may need to wait months for a decision from the court, but the government could act now. It could act today and demonstrate leadership and treat each RCMP member with the respect and dignity we deserve. We are proud Canadians and loyal members of the force. We ask the government to respond in kind and reward the hard work, loyalty, and commitment to all members of the RCMP by recognizing our charter rights. If the court rules against us, the ramification is that every collective agreement and unionized workplace in Canada will be in jeopardy because precedent will be set by the ruling. We believe it will be the beginning of the end for collective bargaining in Canada, as employers could justifiably impose labor programs and deny employees the right to select independent associations to bargain on their behalf. A negative decision would lower the bar for employees, collective bargaining would end, and consultation would be considered adequate. Canadians deserve better. RCMP members deserve better. This unchecked power is not acceptable in a just and democratic society. At this time, I'd like to call upon Rob Priester to address the issue of the RCMP using members' own money to fight against our rights. Rob?
Thank you, Ray. Thank you, Ray. As Ray mentioned, I'm a retired 28-year member of the Royal Canadian Mounted Police, and I'm currently the spokesperson for the Mounted Police Professional Association of Canada. The reason I am still involved in this fight is twofold. I've been involved in this case for 2 decades, and the second reason is that currently RCMP members are prohibited from speaking to you, the media. In fact, they can face disciplinary action for doing so, and they can't criticize the RCMP senior executives or the government. Apparently, that's my job. Today, I want to tell you a little bit about 2 key issues related to this case: the Staff Relations Representative Program and the Mounted Police Members Legal Fund. The RCMP senior managers are saying that the Staff Relations Representative Program adequately represents members' labor concerns to RCMP management. But the SRRP is mandated by the RCMP and is only consulted on labor issues. There's no negotiation. It does not have the true power to negotiate with our employer on our behalf. Many of you have heard the name Janet Merlo. She's the lead plaintiff in a potential class action lawsuit that deals with over 300 cases of harassment within the RCMP. Ms. Merlo just wrote a book entitled No One to Tell. We want there to be someone to tell, and we want to be able to take action on their behalf. RCMP members have never been free to choose their system of labor relations. We have never been given a free choice to form our own system of representation. We've been fighting for over 20 years for our constitutional right to have a labor association that is completely separate and independent from upper management. And now that management-funded SRRP program is using members' own money in terms of what they call the Mounted Police Members Legal Fund to fight against their democratic rights. In every court challenge, the Staff Relations Representative Program, via the Mounted Police Members Legal Fund, has used RCMP members' own money to deny them the constitutional right to free choice in labor representation. The SRRP and the Legal Fund are the same people. They are the staff relations representatives. The RCMP is the only police force in Canada not permitted to form an independent collective bargaining association. Because of this, we are falling behind in every major provincial and municipal police service in terms of staffing, resourcing, pay, benefits, and the ability to provide the Canadian public the level of policing service you deserve and should expect. The RCMP cannot maintain its status as a prestigious Canadian institution or even as an employer of choice when it is 57th on the pay scale in Canada and covers vast staffing shortages with excessive overtime. Members' harassment grievances can remain unsolved for upwards of 13 years, like a case we're dealing with in BC. And members suffering from PTSD and occupational stress injuries who are now off sick now fear for their jobs. An untold number of members are silent about their PTSD for fear of it damaging their reputation. Obviously, the current system is not working. It is failing. It is failing members of the RCMP and it is failing members of the public. The government is trampling the rights of the hardworking men and women of the RCMP. And today we ask the media and the Canadian public to join us and demand the respect, fairness, and equality all RCMP members deserve. Assisting us in this appeal are 7 interveners: l'Association de la Police Montée du Québec, la Confédération des Syndicats Nationaux, the Canadian Police Association, the Canadian Civil Liberties Association, the Public Service Alliance of Canada, and the British Columbia Civil Liberties Association. As Ray mentioned, if the court rules against us, the ramification is that every collective agreement and unionized workplace in Canada will be in jeopardy because precedent will be set by the ruling. So these labor groups have formally intervened in the court on our behalf. At this time, I would like to introduce Mr. Gaétan Delisle, the president of the AMPMQ, to address you in French. Gaétan.
Merci. Merci, Rob. Merci. Alors, bonjour. Je me replace ici à plusieurs reprises dans toute l'existence de l'Association des membres de la police montée du Québec. En fait, j'aime pas ça reprendre mes confrères, mais ça fait déjà 35 ans qu'une demande pour obtenir le droit de représenter les membres par une association qui est légale et par une association qui est indépendante. Et je vais vous référer à la cause Gaétan Delisle, dont moi-même, versus la Reine en 1999, où la Cour suprême avait statué qu'on avait le droit d'avoir une association indépendante, de représenter ses membres, sauf que dans cette décision, on l'a arrêté court, la définition de est-ce que l'employeur peut entendre les redevances d'une association? La réponse c'est non. Il n'y avait aucune obligation dans la décision de forcer l'employeur à s'asseoir et négocier. Donc, il parraine techniquement ce que le système à l'interne de la GRC, qui s'appelle représentant divisionnaire, nous, on les appelle les pantins du commissaire. C'est sûr, parce qu'ils sont payés, ils sont promus et également, ils se rapportent directement au commissaire. Alors, sans plus tarder, s'il y en a qui ont des questions pour la cause, parce qu'on est dans la cause présentement, c'est ce qui se passe là. Et ce que l'on veut obtenir, encore une fois, c'est le droit d'avoir une association indépendante et de négocier collectivement comme tout autre citoyen canadien. Merci.
Au micro, techniquement, en termes de hiérarchie, en termes de chronologie, là, vous parlez de 99. Depuis 99, qu'est-ce qui s'est passé pour mener aujourd'hui à ces audiences-là?
Il y a eu le dépôt de la cause, la MPAO, qui, parce qu'il y avait un vide dans la décision de l'île. Pardon? What year did you introduce the case? It was 2002?
2006.
En 2006, parce qu'il y avait un vide à savoir est-ce que le système présent est constitutionnel ou pas. Vous allez vous rappeler qu'en 2006, le juge avait ordonné à la GRC de changer la loi. Il y a eu un projet de loi qui a été déposé devant le gouvernement, le bill C-43, qui donnait le droit à avoir une association indépendante. Par contre, lorsque la décision de la Cour d'appel a été lancée, automatiquement, le gouvernement a cancellé le bill et il en a mis un nouveau sous l'égide du nouveau commissaire de la GRC, le bill C-42. Puis rappelez-vous aussi que dans ce bill-là, le roi est maître de tous les membres de la GRC, c'est le commissaire, c'est plus personne d'autre. Donc, il a enlevé tous les droits qu'on avait gagnés depuis belle lurette, depuis que moi, j'étais représentant du diagnostic, soit en 1977.
Est-ce que vous pensez qu'avec le gouvernement actuel, on voit son penchant un peu antisyndical? Est-ce que vous pensez que vous avez quand même des chances qu'il se passe quelque chose là-dedans?
Et c'est la raison pour laquelle on est devant la Cour suprême. La Cour suprême, c'est, selon nous, l'endroit qui doit appliquer les lois, qui doit faire appliquer la charte vis-à-vis de tous les citoyens canadiens. Cette décision-là va toucher ça. Et si il y a une négation de la part de la Cour suprême, bien là, écoutez, je ne sais pas ce qui est en ligne ensuite de ça pour l'application de la charte. C'est là qu'est le débat présentement.
Can you give me an idea of the kinds of arguments that are being used currently against the unionization? I mean, I understand why in 1920 the ban was first put into place, but what kind of arguments are they using against you right now?
I think one of the primary ones is that the staff relations program provides a medium or venue whereby members' issues can be dealt with. That's what they're saying. But on the ground floor, the program is failing the members. So, as well, that they are concerned that with unionization of the RCMP, that the employers are going to lose the ability for the employees to do what they're required to do if a union or an association represents them. I think that's a key bit. But one of the things, as in every other police association, MPPAC, we don't seek the right to strike. That's a non-starter. It's a non-issue for us. Most police are deemed essential services. So in other agencies, they do work to rule things, but it never impacts the delivery of policing services. So in our case, we just want our members to be given the right or the chance to have a choice.
If I could just add to that, I think one of the things that we're running up against is that our RCMP management right now figures that the current system is adequate. I guess if you never ask the question of the membership as to whether they're happy or not, you never know the answer. And in my time in the RCMP, nobody came to me to ask whether I was happy with the current system or was interested even in a collectively bargained regime. So if you don't ask the question, the closest they've come is when just prior to me leaving in 2010, they actually asked what the percentage of people that are happy with the current system. And if my recollection is correct, it was about 11%.
Could you go into a little bit more detail about the SRP, like how it works and what your concerns are with it?
I'll let Gaetan address that because he was a member in the program, so he can speak to that.
In English, if possible?
Oh, I can do it, but I think you'll have to rephrase the question because I couldn't hear.
The staff relations representative program, how does it work?
How does it work?
Yeah, and why you would consider that it fails members?
Personally, I was re-elected in the program 13 times. So I served 33 years in the RCMP as a div rep. At the same time, I was the president of the association. But the div rep is being used by the RCMP because members elect div rep in different regions to represent them. And at the outset, when I said that the div rep were used as les pantins du commissaire, I don't know what the correct word is in English. Pardon? Muppet. Okay. Because they are paid, they are promoted, and at the same time, they work on behalf of the commissioner and they report to the commissioner. So the div rep system is part and parcel of management. And therefore, when you have an issue that is at the core value of the members, you cannot express it because there's a code of conduct within the div rep system that does not provide members of association to run for election of div rep. So there's a code of conduct that was specifically designed for it. So technically, when it's being used, the div rep system, actually, when it was founded in 1974, I was there, it was exactly to combat the unionization of members in the RCMP, and it has ever since been employed to do that. Does that answer? In part, or?
Par le fait que de vous syndicaliser, ça ralentisse le système ou que ça fasse en sorte que la GRC soit peut-être moins mobile ou moins efficace, le fait qu'il y ait des unions, qu'il y ait des négociations, que ça ne se reste pas à l'interne, mais que ça soit sorti à l'externe, qu'il y ait plus de combats entre les employés et le patronage?
La question, c'est est-ce que ça va faire ça? Je vais juste vous référer aux différents corps policiers qui font exactement le même ouvrage que la GRC, soit l'OPP, la Sûreté du Québec. Ils font exactement le même travail que la GRC. Et est-ce que cette réponse-là, vous êtes capable de l'adresser? Je crois que oui. Ça n'enlève pas le service. Ça ne fait aucunement. Mais il y a une chose qui ressort toujours dans tous ces modèles-là, c'est que ça l'aide le management à faire sa job. Dans le sens qu'il y a des paramètres qui sont établis en disant voici ce que vous allez faire, voici ce que vous ne pouvez pas faire. Puis si on n'est pas d'accord, on s'en va devant un arbitre. On n'arrive pas 13 ans après, comme Rob disait, avec une décision sur un grief. Non, on s'en va devant un arbitre et la décision est rendue. Ce qui enlève toute notoriété au management et aux autres, parce que sûrement, il y a des décisions qui ne font pas l'affaire des membres, c'est sûr. Et vice-versa, il y a beaucoup de décisions qui ne font pas l'affaire non plus des boss. Mais par contre, c'est la loi, c'est ainsi que c'est fait, et on passe à d'autres choses, on ne revient pas tout le temps avec la même. Ce qui se passe présentement avec le nouveau projet de loi, c'est qu'il enlève tous les paramètres qui avaient été établis par des décisions antérieures à différents niveaux.
Vous pouvez gagner du fait de vous syndicaliser?
Techniquement, la meilleure réponse là-dedans, c'est d'avoir du monde qui sont indépendants de l'employeur pour être votre voix, pour être vos représentants et d'avoir confiance en eux et non pas quand tu adresses le management, mais ils peuvent te dire n'importe quoi aussi. Et la confiance règne pas. Je ne sais pas si ça répond.
Okay. If there's no more questions, okay, go ahead.
Are we just talking about police officers or staff of RCMP? All
Just members. Yes.
in force.
Many people that work in the RCMP, I'm sorry, many people that are currently working for the RCMP are already public servants and they're represented by PSAC.
And how many officers are we talking about? Are in the force?
That number ranges 18,000, give or take. Okay, thank you very much for coming to our conference, and we're available to have one-on-one discussions after. Thank you.